Hi everybody, welcome back to my channel. Today's topic is how to terminate an alimony obligation, which is a topic that I know a lot of people are really interested in. And I have good news for you for the most part, okay? Even if you have entered into a divorce that calls for quote unquote permanent alimony, there is a way out for you in all likelihood, okay? Permanent does not mean permanent anymore. It used to, but it doesn't now, okay? That's not to say this is always easy. All I'm saying to you is it can be done, all right? Now, there are four main ways that we can terminate alimony. I'm not talking about reducing alimony. Reducing alimony is a little bit different, right? Let's say you have an obligation that's based on you making a certain amount of money and your spouse only making a certain amount of money, and now either you make significantly less or she makes significantly more, or some combination of that, or maybe you've suffered some kind of disability. Then we can get your alimony reduced. And in terms of disability, sometimes we can get it eliminated entirely, okay? I have to look at the language of your divorce to see if there's what we call anti-lepus language in there. That's a little bit different, but we're not really talking about reducing alimony right now. I want to talk about just ending it outright. Now, the first way of ending your spousal support obligation is if your spouse got remarried, in which case, congratulations, you just won the lottery. There is not a whole lot you have to do. You simply file a motion with the court. You say, Judge, I know that my ex got remarried. Here's how I know. Here's the Facebook post, or I know through friends or whatever. And you submit that motion to the court. And in all likelihood, it's just going to be granted without even much of a hearing, because I've never seen somebody get married and then deny that they were married. Okay, they might try to hide it, but once they're found out, they generally just fess up to it. And then good for you. You're done paying spousal support. You won. Alternatively, and this is a little more morose, but if the person you're paying spousal support to has died, well, obviously you don't have to pay anymore. Again, you file your motion, and that's the end of that. But those are the easy ways, okay? The two more common ways, the one, at least in terms of the people who call me, are they've either discovered that their ex-spouse is cohabiting, which is one thing, or they've simply reached a point where they want to retire. Now, these are very different things. If someone is cohabiting, it's not as simple as telling a judge, hey, I found out that my ex-wife is now living with her boyfriend, okay? It's way more complicated than that. You have to show that your ex-spouse has entered into what's called a mutually supportive, intimate relationship with another person, okay, that has some degree of economic codependence. So the factors that the courts are going to look at include whether or not the couple shares finances or living expenses, how the relationship is perceived socially and within family circles, whether or not they share household chores, and the duration and nature of the relationship. So, for example, one of the defenses is going to be, well, we're not cohabiting. This is just a roommate, or this is just someone I've taken in, or something like that. The courts are really going to go through these factors. Are you sharing finances? Are you sharing living expenses? Are you considered to be boyfriend, girlfriend, or engaged, or something like that? How long has this been going on? And one of the things that happens is you find out that your ex is cohabiting, you file your motion, you got all your evidence there, and then she decides she's not going to cohabit anymore. And then what do? Then the court has to make an equitable decision. Does it make sense to terminate alimony? How long was this person doing this? Is it bona fide? I mean, it gets complicated. That is probably not something you can do on your own. That's something that you really need to contact an attorney for, and be committed to spending a good deal of money in terms of maybe even a private investigator, but certainly on your attorney, who's going to have to do a lot of discovery and probably a trial on this. Now, I have won these. The most recent one, I knew a woman was cohabiting because I had like many months of Facebook posts that she was silly enough to either make public, or I think the party still had mutual friends, and one friend told my client. And so I had this treasure trove of Facebook posts showing this woman traveling the entire world. And so when I said she was cohabiting and she said she wasn't, I said, well, here you are at an exotic location taking a mud bath with this guy. Here you are taking some kind of weird intimate shower in a waterfall together. Okay, here you are out to dinner 100 different times, posting on Facebook about it. Okay, and you're also living together. So in that case, because I was able to catch her lying, and that's a big thing, right? It's not enough to catch somebody in the act. If you can be enough, but if you catch them lying about it, then a judge is really going to be unhappy. All right. So in that case, I had a lot of evidence against that person, and we were able to prevail. But I'm telling you, it's not enough just to say, well, I see my wife's car at this guy's house all the time. I mean, that's something, but then that's a start, but then you have to get into the discovery period, okay? All right. What about if you just want to retire? And I think this is the most common reason that people want to stop paying spousal support, or at least why they think they shouldn't have to pay spousal support anymore. I'm sure nobody wants to do it, right? What I can tell you is that if you are retiring or retired and it's good faith and it's at full Social Security age, there is a high likelihood that we will be successful. But I want to show you something, and you can't see this, it's off camera. But this is the most recent one of these applications I did. This is right here, one of the trial binders, okay? And then this one here is the second one, all right? I think actually the smaller one was mine. There goes my lamp. The smaller one was mine, and the bigger one was the other side's. I think he had over 100 exhibits. I think I had like 60 something. And it was, I think, a 3-day trial I had to do. There was a ton of discovery I had to do, which you can see. Depositions and financial records and all kinds of stuff. And we won, okay? But it was a ton of work. And for this person who was paying tens of thousands of dollars per year in spousal support, it made sense to make this investment, all right? But it was a lot of money. And it was a lot of money for the other side as well. Now, what are the factors? All right, first things first. If I'm your attorney, the first question I'm asking you is, were you divorced prior to or after September 10th, 2014? And there's a big difference. Prior to that, there was something called permanent alimony, okay? After that, we got rid of permanent alimony. It still doesn't exist. Regardless of whether you're divorced before or after September 10th, 2014, we can get your alimony obligation terminated, but there are slightly different factors. I mean, they're kind of the same thing, but you should know the difference. If you were divorced after September 10th, 2014, and you have reached full Social Security retirement age, which right now is 67 years and 4 months, I believe, then there is a presumption that your spousal support obligation should terminate, okay? And it's a presumption that your wife, we're going to call it wife or ex-wife, can rebut based on certain factors. And I'm just going to go through a few of them very quickly. So the courts are going to look at the age and the health of both parties, the length of the marriage, the economic dependency during the marriage, the amount of alimony already paid, the financial situation of both parties, any sacrifices made by the supported spouse in exchange for higher or longer alimony. All right. Here, the burden is on the spouse getting the alimony. So you're 67 years old and 4 months. You put in your application to retire and terminate your spousal support obligation. The court says, okay, good. I'm going to agree with you unless your ex-spouse can show me why I shouldn't. So the burden's on her, okay? If you want to retire early, the burden is on you. And I'm just going to tell you right now, because I want to be straight with you, there is only a very slim chance that a court is going to let you retire early. If you're disabled, that's one thing. But, I see a lot of these cases where, guys were like police officers, or maybe they were in financial services and there was an expectation they'd retire in their 50s or early 60s or something. Good luck. You're going to keep paying. That's just how it is. I mean, I know that there are factors, but it is a tall task to ask a judge to terminate early. It's really unlikely. I'm just being straight with you. Your best bet is just to wait until you're 67 and 4 months. But, it's your money and you can invest it how you want. And if you want to hire an attorney to try to get your alimony terminated, just because you think a judge is going to let you retire at 51 because that's when all the other police officers retired, good luck with that. All right. I mean, I'll take your money if you want to hire me to do it, but you have to understand that that's a long shot. All right. But let's say you have reached full Social Security retirement age, but you got divorced prior to 2014. You probably have a divorce decree or a marital settlement agreement that says you have to pay permanent spousal support, permanent alimony. Maybe you think you're out of luck. No, good news. If you were divorced all the way back then, not only is there a presumption that you're retiring in good faith when you reach full Social Security age, the courts just deem it that. They say, we know you have retired in good faith. But then the burden is still on you to show that ending spousal support would be reasonable. So it's weird because you would think, well, it's not just a presumption. The courts have found that I've retired in good faith. Therefore, why is the burden on me? Well, it is. That's just how it is. As a practical matter, even though we talk about who the burden is on in this case, really the courts are weighing the factors. I don't know that it really matters who the burden is on. I think the courts are just going to look at the factors and make a decision that way. But you should know that if you were if you were divorced after September 10th, 2014, and you want to terminate spousal support now, and you reach full Social Security age, the burden is technically on the other side to prove why you shouldn't. If you were divorced prior to then, the burden is technically on you to prove why you should. But I don't really think it adds too much to the complexity. Although this case here, this giant stack of cases here, that was actually somebody who had retired, I think in 2012. So maybe, sorry, he had divorced, I think, in 2012. And we were able to successfully terminate his spousal support, but only because he had reached full Social Security age. So my point in doing this video is not that I have any illusion that you're going to be able to watch this and do this by yourself. Like there are certain things that you can do by yourself. And I'm usually pretty upfront about that. There are certain things you can't. If your former spouse has unfortunately passed away, you can probably just file that motion by yourself. If they've gotten remarried, maybe you can do it by yourself. If they're cohabiting, you certainly can't. And if you have simply retired, you really are going to need an attorney, because the other side is not going to give up spousal support easily, especially if they've got some marital settlement agreement that says they're supposed to get permanent alimony. And that's what happened in that case. And in that case, I remember, the wife was saying she didn't have any money saved up. But one of the factors for the pre-2014 cases is the ability of the supported spouse to have saved. And she was saying, well, I haven't saved anything. Well, the reason she hadn't saved anything is because she spent all her money. She'd gotten a few $1 million in spousal support. Okay. And so the issue wasn't so much had she saved, but did she have the opportunity to save? And because she hadn't, it didn't matter as much as it should have that she didn't have enough money saved up. And by the way, this was somebody who was fully capable of working. She just wanted to live off of her former husband. And, he had paid a ton of money by then and it just wasn't fair anymore. All right. So anyway, if you have one of these situations and you want me to review your marital settlement agreement to see if you can reasonably have your spousal support obligation terminated, just give me a call. I'll take a look at it for you and we'll see what we can do. All right, guys. Thanks for watching. See you next time. Take care.